Hello, everyone. We're here for the live webinar, EB2 NIW, RFEs and NOIDs, tips, tricks, and how not to catch it on the RFE. Thank you, everybody, for being here. It's a pleasure to have so many people connecting. We're really happy because we have more than 220 people registered, so we expect around 120 people attending, so it's going to be really, really fun. If people can share where they are located right now, that would be amazing. What city? I know we have, okay, New York, Brooklyn, California, Fort Lauderdale, Dallas, Brooklyn. I see a lot of familiar names. Sherry, hi Sherry. New York, Orlando. Okay, welcome everybody.
Everyone.
So we're gonna be waiting for a few people to jump in, let's say 1 or 2 more minutes, and then we'll get started with the introduction and then we'll dive in. We're really excited about today's topic. Our guest is very knowledgeable and we're gonna touch up on very complex but interesting topics about the EB2 NIW. Where else? Miami, Phoenix, Austin, San Diego.
Ho Chi Minh. We got
Huh?
Ho Chi Minh City.
Oh, wow. Ho Chi Minh City. Vietnam, Dallas. Great. Okay, so we have 88 people right now. Let's see. Okay, so just for everybody to know, we have the chat where you can send us any comments that you wish everybody to see. We also have a questions tab on the right-hand side where you can add any questions. We also receive questions from people when they registered. So we're going to touch on a few of those as well in our topics and also at the end. So we'll try to get to all of them. Ooh, hello from Brazil.
Brazil.
Seattle. And then we're going to also be sending a few polls. So if you can answer on that tab as well, feel free to. Okay, we have 96, 98 people already. So let's get started. There's already people wanting to ask questions.
Already
Please, let's
substantial
talk
merit.
about substantial merit.
Jumping right to it.
Okay, I need to make the introduction first. Oh, we have Morella here. Hi, Morella from Miami. Amazing. Okay, so we have enough people already in our webinar. So let's get started. Let me just shift this. Okay, great. So welcome everybody to our webinar, EB2 NIW, RFEs and NOIDs, tips, tricks, and how not to catch it on the RFE, hosted by Joorney Business Plans. We are thrilled to have you here. As many of you are aware, Joorney specializes in preparing business plans for immigration, including the EB2 NIW category. This year, Joorney celebrates 10th anniversary, and we are grateful to the immigration lawyers who have contributed to our growth. At Joorney, we understand the value of sharing knowledge among experienced legal professionals. Our webinars focus not only on success stories and best practices, but also on learning from mistakes and sharing tips and tricks for the benefit of immigrants. Today, we are fortunate to have a wonderful guest who will candidly share what he has learned through RFEs and NOIDs. We are also pleased to announce that this webinar has been accredited 1 CLE credit by the Florida Bar Association, providing an additional benefit to our partners. The code would be provided at the end of the event. And if you're interested, we invite you to check out our other webinars on our YouTube channel. This is actually our 3rd webinar regarding the EB2 NIW, so it would be great if you can check those out on our YouTube channel. Please note that this is a webinar intended for immigration lawyers. However, if you are an applicant joining us today, feel free to listen in and direct any further questions to our guest speaker. Some technical vocabulary may be used during the presentation. Last but not least, we want to clarify that Joorney does not provide any legal advice. We collaborate closely with our esteemed partners for that aspect of the process. And as I said, we are thrilled to see the impressive turnout of over 220 registered participants today, and we hope this webinar enriches your practice. I am Marianella Manzur, Director of Sales and Marketing at Joorney, and I will be your host for today's session. Okay, so now let me introduce our amazing guest, Gregory Bowen. Gregory is a Miami native, fluent in Spanish, English, and Portuguese. He holds multiple bachelor's degrees, a master's degree from the Florida State University, and a Juris Doctor from Nova Southeastern University Shepherd Broad Law Center. Mr. Bowen excelled academically, graduating with honors and receiving various prestigious scholarships and awards. His expertise lies in business and immigration law, where he represents clients and businesses in the US and abroad. He specializes filing visas based on talent, investment, or employment history, guiding clients through the immigration process. He's well-versed in litigating and providing transactional legal services, staying updated on changing laws and their impact on business and on immigration. With his prior experience as a judicial clerk, Mr. Bowen has a comprehensive understanding of governmental procedures and administrative laws. He has also contributed notable work in legal research and writing on civil and criminal law, professional ethics, LGBT issues, and Florida small claims rules annotated. Additionally, Mr. Bowen has worked with the United Nations and the Republic of Panama on various policy matters. Gregory Bowen is a licensed attorney in the state of Florida and provides clients with clear guidance, effective legal strategies, and comprehensive support throughout the immigration process. Plus, last but not least, Greg has worked with Joorney Business Plans for many years now. So we want to thank you, Greg, for accepting our invitation and being here with us today.
Thank you so much. I'm very honored for the ask and to be here with other colleagues, and I'm looking forward to discussing the topic at hand.
Amazing, Greg. Thank you for being here. And I remember you said in the introduction that that it may be too long, but of course I need to go over all of your experience, so it's not easy.
Right.
I'm glad to know that it's long, and there's a lot that people attending here can learn from you.
I appreciate that. For the sake of time, the limitation of time, I won't add to it. There's more.
There's more, but wait, there's more.
But wait, there's more. No, but we can jump right into the EB2s. I know that's what everyone here is really for.
Okay, wonderful, Greg. So let's start. Okay, so we're here to speak candidly. So if you can quickly tell us a bit about yourself and your experience with EB2 NIW, so we can provide our attendees with some context about your expertise, but specifically on NIWs, that's it.
Right. So I cut my teeth with employment-based visas, and then that's where Joorney and we've come to work together on EB2s and business plans. And I've really handled a lot of EB2s over the years. So when Joorney approached me about this, it kind of just seemed natural to discuss everything that we've worked on over the years, all the issues that I think I've highlighted for you guys to cover in business plans, and how I've communicated to you over the years, how your business plans have really helped me win my EB2s. So I think this seminar was a natural evolution of that relationship, right? So to answer your question, though, in business immigration, primarily, I cover a wide range of other immigration topics in my practice, but EB2s, employment-based visas, is where I cut my teeth, and something that I feel very comfortable with and confident with. And we were discussing this before we jumped in. I have a passion for this area of the law. So I'm excited to talk about it.
Great, Greg. Thank you so much for accepting the invitation. And it's true. I mean, at Joorney, we permanently learn from other partners, and our intention is to be able to share that knowledge with everybody who also works with us, right? The better that we get, the better the outcome for the immigrant. So we're happy to have you here. So let's dive in. So as the topic refers to RFEs and NOIDs, let's be honest, it's very challenging to mention to somebody who's interested in the EB2 NIW the possibility of getting an RFE when you're trying to sell to them your services at the same time. How do you explain probabilities to clients, and what do you recommend to other lawyers?
I avoid absolutes, right? There are individuals out there that can say, you know, I will guarantee an approval. I think as attorneys, we have a professional ethical obligation to present to the client the reality of the situation, right? And an analogy that I'll use, I'll say just like a doctor, right? You go into the hospital or you go in for a procedure, and you have to discuss the potential of death, right? To not be so morbid in an example, but you have to tell them the risks, right? That's what we attorneys are supposed to do. We're supposed to present the risks to the candidate, to the client, and then let them know what their options are, and really help them protect themselves from their own actions, right? Sometimes clients have the best intentions, and those intentions, if not placed in context, might result in a denial, right? So we'll discuss examples of that later on in this seminar, but in this discussion. But you just have to, as an attorney, realize what your role is in this process. It's to be candid. It's to be real with the candidate, not to sell false promises or false dreams. And I would recommend, I personally do not speak in absolutes, because I'm aware of the climate when it comes to EB2s specifically. So I don't give 100% guarantee, because as we'll discuss today in this talk, there's issues. There are RFEs, there are NOIDs, there are ridiculous denials. So that's how if I've answered your question there, Marianella, that's how I answered it. That's how I address it with the client.
Okay,
I just
great.
right into it, and I say it's a 50-50 split that you might get an RFE, and we'll discuss why. But
okay, wonderful. Yeah, I mean, honesty is the best path, and just managing expectations, right? Because so that they know that it is a possibility, and it doesn't mean that it's going to be denied, but it's a possibility that needs to be managed when it arrives, right?
Right.
Great. So another question. So I know a lot of RFEs are coming back, and some of them are mentioning that they didn't receive certain documents that were most of the times already submitted. There are certainly a number of rumors about why that is, but could you share with us how you try to safeguard against this and track documents that you sent to USCIS?
Of course, and to even highlight the phrasing, you know, to use your question, I've had USCIS say that they did not receive any documentation whatsoever, kind of blatantly making an assertion or making a statement that is patently false. Because the client and I, or at least I know, that I've scanned everything. I have a USPS tracking when I mail it to the USCIS center, or let's say the Texas Service Center. I have a scanned filing that's time-stamped of when I scanned it, so that I can show the client that I did in fact send everything that we said we were going to send, because that's now when an RFE comes in and the client reads the RFE, and the RFE says no evidence was submitted, right? Instead of they didn't say we didn't receive, right? They didn't phrase it that way. They didn't say, oh, we didn't receive. No, they said no evidence was submitted. So that the client sees that, they question the attorney. I show them, not only did I send it on such and such date, here's the USPS tracking, right? I put that in my cover letter, and that's the proof. That's one of the ways that I try to safeguard the client from that patently false allegation from the government. So that's something that I recommend doing, something that I've learned over the years.
Okay, great. So that you can show the tracking, but you don't use that tracking for USCIS. It's more to show the client that it was submitted, but then you submit the documents again.
Correct. I do submit the documents again, and in my cover letter, I will say for the record, I'm resubmitting the document that was previously submitted, so that there is a written record that there was an issue, right? That I'm always sticking to my guns here, that I did send it, that USCIS should have reviewed it. And I'll even discuss that, let's say in a response to an RFE. I'll say that this was overlooked. The failure to adequately or meaningfully handle the evidence is something that USCIS is required to do in coming to their analysis or coming to their decision. And if they've overlooked it, or if they don't have it in the record, when I know that I've sent it or that it was presented, then that's something that could lead to a lack of due process for the client. So that's something that I address in the RFE response. But again, when it comes to the technical way of submitting it, at least for the client, I have the scan filing and I have the USPS. So this has happened before. Let's say that they'll say that they never received the I-140 petition, right? In later on, I have that USPS tracking just to confirm that they did receive it. So I've never had that come up too often, but it's just something to save for the future, right?
Okay, wonderful. That's a great tip to keep in mind. So Greg, the NIW nowadays has become so popular. What's your opinion on the natural subjectivity of the natural interest element of the NIW these days?
It can be a bit irritating how some officers can become islands unto themselves. They'll try to act unilaterally, or they'll invent novel criteria that is not within the regulations. It's not within the law, right? So they'll state things in ways that is, again, not the letter of the law. And it's frustrating. It's frustrating. It comes with the territory, with that element of discretion that lies within the law. But it's something that we as attorneys have to keep our guards up, right? We have to realize that it's becoming an adversarial process when it really should be. The law is meant to be to be applied as broadly as possible, right? To allow for a broad spectrum of evidence, of benefits to be considered. So when you see an officer come in and kind of narrow the endeavor or narrow the evidence in such a way, or mischaracterize it in such a way to their interpretation, right? You have to go back to what you initially presented and say, no, officer, respectfully, the way you've interpreted it, is incorrect or a mischaracterization. Look at it this way, or this is the way that it was presented, right? So to answer your question there, when it comes to the subjectivity of it, it feels like an uphill battle. I think it's a battle that we can win, that we're trained to win, right? Or trained to overcome as attorneys. But it's a part and parcel of what this EB2 is, the discretionary element with the waiver. So it's something that it's just part of what we do, and we have to remember to keep our guards up and to stick to the letter of the law and the evidence presented, right?
Great. Greg, can you tell us a few examples of cases that you were working on, and what documents you usually include to make sure you have things covered in a situation like this?
Right. So, in an RFE or let's just in an EB2 in general, we can start with that.
In general.
So when it comes to the advanced degree, I like to provide an equivalency, right, of the bachelor's degree. That's something that you can work with a third-party partner on. But I like to, if we're arguing advanced degree, then you should have that advanced degree. If you're arguing exceptional ability, then you don't need that advanced degree equivalency or that equivalency for let's say a bachelor's degree. So depending upon which qualifier, right? Advanced degree or exceptional ability. So degree, and when it comes to employment experience, whether it's the 5 years of progressive experience for the advanced degree or 10 years experience for exceptional ability, letters that evidence that progressive employment experience, letters that are specific as to dates of employment. And then depending on the criteria that, let's say that you're arguing for exceptional ability, if it's membership, proof of that membership, if there's a member number, a member ID, proof that that organization is pertinent to the individual's field of expertise or their endeavor. Let's say that, let's use an example with the STEM field, engineers. Usually, let's think about it in a logical standpoint, right? An engineer usually has a membership with a college of engineers, usually has a license to be an engineer. So think about it just at that 30,000 foot level, right, from up above. What logic should that profession have? And let's show that. Degree, license, membership. That's what usually goes into an EB2, okay? And then when we're talking about proposed endeavor, now talking about the business plan, figure out what that endeavor is with the client. I don't invent endeavors for my clients. I have my clients perform an exercise, right? I have them sit down, and if it takes 1 or 2 consultations, I say, think about what you want to do in the U.S., right? What is it that
therapy.
you right?
That's therapy.
Right.
That's included in the fee, right?
Right. What is it? What is it that you want to do in life once you move to the U.S.? And if you know at a certain point that you want to work for yourself, or if you want to start a business in 2 years, or once you become a resident, then that's something that you should put in your EB2, and something that we should discuss, and you should evidence that with a business plan with the 5-year projections and all that. So when we're discussing the endeavor, if you have potential clients, colleagues that are willing to work with you on the advancement of some proprietary material, a patent, if you have those things in line, get your ducks in order at this stage, right? When you're preparing the cover letter, and present that, or present as much as possible at the beginning. This is where we came up with that title of the Catch It on the RFE.
Exactly.
And not to go too far ahead of ourselves, but some individuals will just present the bare minimum and then catch it at the RFE and explain things later. I like to explain as much as I can and evidence as much as I can at the beginning.
Okay, and we're gonna touch a little bit on that a little bit further, right? Do you give your strategy straight away, or is it adapted after you receive the RFE?
Right.
So we'll get to that in a little bit. Okay. Okay. So one of in our conversations that you mentioned that you talked to your colleagues about best practices, tricks, and you mentioned a few that you had benefited from and that you would also like to pay it forward. And I think this is one of my favorite sections of the webinar. Can you share some of those so our audience can also learn how they can all get more approvals?
Right. So to go over what we prepared there, the government links, looking up what the Congress at your state and federal, right, Congress is discussing as a priority. What are your federal priorities, your federal initiatives? What are your state initiatives? So when you go to the US Congress's website and you look up, let's say, water initiatives or scientific endeavors or diversity initiatives, look at what bills have been passed, look at what's being discussed on the floor, because you'll get a feeling for what is that hot topic, right? So we know that there are these initiatives right now for infrastructure, internet. Those are things, just to use one of the many of the thousands of initiatives that are going on at a federal level. Just let's focus on that. You find a bill and you cite that bill in your cover letter, right? And you try to make the connection for the officer that what your client intends to do will go to meet or support or draw from that initiative. If there's money being invested and your client has a plan to tap into that money or tap into that initiative, right, or to support that initiative, highlight that. That's what your role is for the client, to understand what it is that they want to do, and then see where in the current state of initiatives or the policy frameworks where that fits in. And then at a federal level, just to use Florida as an example, Florida's economic Office of Economic Development, I should say, they had a plan, a 5-year plan, and they set their initiatives. And I would highlight those initiatives and then speak or connect those initiatives to what my client was doing at a state level. And every state has a set of goals, has a set of initiatives, things where they're failing at a state, regional level, municipal level. So see where, and that's just one aspect of the case. See where your client can kind of tap into those federal and state initiatives. Another tip is to incorporate the citations used by, let's say, not only Joorney, the business plan, because Joorney's business plan comes with citations. Tap into those citations, include them in your argument, right? Don't assume that the officer is going to look at that, click on that citation, incorporate that printout of that relevant material into your case, so that you know for a fact that it was presented, that the officer sees it, the officer has an opportunity to read it, right? Do as much for the officer as you can, right? When you tap into a citation, see what other relevant material might source it or build upon it, and kind of present your case around that material, right? So present your arguments around those citations, so that everything kind of meshes. Another tip is to look at ONET. ONET is something that comes from the Department of Labor in conjunction with the Bureau of Labor Statistics. Incorporate that material into your case wherever possible. If when the client comes to you and says, this is what I intend to do in the US, see, now talking about ONET, see if that can be encapsulated by one or more occupations. So if the individual's endeavor is encapsulated adequately by one occupation, one SOC code, then the labor certificate is probably meant for them, right? But if your client's profile is so unique and so complex, or what they intend to do is unique and complex, and that endeavor contemplates more than one occupation as defined by ONET or as defined by the SOC code, then an argument for a waiver can be made, right? That's something that I've learned at an AILA conference for those attorneys that are members of AILA. Going to your AILA conferences, I had an opportunity to hear that directly from the attorney that litigated Danisar. So, right. So if you know that, if you see that the occupation contemplates more than one, the proposed endeavor, I should say, contemplates more than one occupation, argue that and be sure that you can evidence that, right? So when you go into the business plan, or when you go into the letters of potential clients or colleagues, make sure to argue how and why that occupation is unique and can't be served by the labor certificate process, or how and why that candidate is unique. I'll use an example. Not every architect is also a project manager, right? And certified in project management. Not every project manager is an architect. So if the endeavor contemplates these two things, then it potentially could merit a waiver, again, depending upon the specific endeavor presented, the specific candidate's profile. So that's just an example. Another example, academic transcripts, touching on something that we discussed before. What should you present in an EB2? You should, and I said you should present the proof of that degree. Well, part of that is not only the diploma, but the academic transcripts, right? So when you get an equivalency done, they usually will not, if the third-party company you're using is worth their salt, they won't give you a equivalency without looking at the transcripts, right? To see that it really is undergraduate or graduate level courses that were taken. If you see in the transcripts that there is perhaps some electives that your candidate, your client took that can now be used or referenced in your EB2 case, you should jump on that. I'll use an example. I had an approval for an individual that was, he had a bachelor's in psychology, right? But he really enjoyed organizational psychology, at how it applied to organizational management, HR, strategic organizational planning. And that's what he ended up working in after graduating, right? And the proposed endeavor touched upon that. I received an RFE stating that the proposed endeavor had nothing to do with the bachelor's degree in psychology, because the officer was only looking at the word psychology, right? So I had to go in there and say, no, psychology is more than what you assume it to be. Psychology also, or the field of psychology, also discusses organizational management. And that's why this individual went on to pursue that in their career. And that's why they now want to work in that field in the US, right? You have to connect the dots for the officer, do that work. And that's just another tip, right? And then resume. When somebody comes to me for an analysis of eligibility, I'll look at their resume. And after a while, if you're a new attorney and you're new at this, you may not get it at the beginning, but after a while, you'll begin to see it right at the jump, right? You'll see where that individual came from, how they progressed in their field. And if something seems logical, right? If going from intern to associate to manager to executive, and then they became an entrepreneur, and then they've excelled at that, then entrepreneurship, let's say, to use another example, EB2 example, then entrepreneurship in the US is the next logical step, right? So the resume, look at what is the logical sequence of events, look to see if you see any trends. To use another example, I had another engineer that went into quality control, right? Their career just kind of progressed into this very niche area of engineering, quality analysis, as it pertains to water and sanitation. I saw that, and what this individual wanted to do in the US was exactly that. And they had some contacts that were interested in their services, and they wanted to work, they wanted to start a company and address the issue of water sanitation in the US. And there's the EB2, right? And a business plan was recommended, and that case got approved. So really try to see that for the client and talk it out with them. So as you see these trends, confirm that with the client, see if that is something that they're interested in doing in the US, and see if you can turn that into the proposed endeavor. So that's just another tip, I guess I could say, after doing this for so many years. Something that, again, where the business plan comes into play. A lot of individuals, it surprises me that they don't realize that the business plan is such a valuable thing to present, right? It sometimes they think about it as just something that you present, like if you're trying to apply for a loan, right? A business plan, I had that question once, like why a business plan? Why do I have to send that to the government? I'm not applying for financing. So I said, no, a business plan, it's a traditional document. It's a traditional piece of evidence that kind of provides a 5-year projection of where you intend to take things. There's a lot of value there. And it'll take what you have in mind and kind of build upon that. And it's a wonderful tool. So I think we've covered all the tips and right?
Wonderful, Greg. Thank you so much for those tips and tricks. For the business plan, not because we do them, but not only because of that, but we've been seeing in the RFEs when people don't submit them, they are being requested immediately, and we've seen that a lot. Of course, there are some approvals that happen without them, people who don't choose to include it like at the start.
Right.
But in general, we see so many people coming back for business plans after the RFE as well. And I'm going to touch on that as well, as to why you choose to do it initially and not maybe wait for the RFE. But before we dive into that, I wanted just to do a little recap on the tips and tricks. So we have government links, bills passed, executive orders, business plans, of course, making sure that sources and citations are not only incorporated, but for lawyers to also take those sources and citations and go look for additional documents that may help them with the file.
Right.
Looking at ONET, Occupational Information Network, under the U.S. Department of Labor in conjunction with the Bureau of Labor Statistics, to get also hints of how to strengthen the case from that side as well. Right. And then academic transcripts, seeing the courses that have been taking, and from the resume, getting hints on that progression.
Right. One more I wanted to touch on is unemployment statistics. Another thing that I've found useful, if you know that in the consultation, I ask, so where do you intend on living? And if they intend on living in an area that has a high unemployment rate, look up those statistics. What is the unemployment rate in that region or in that municipality? What is what is it in comparison to the national unemployment rate? And see if an argument can be made that the individual's endeavor looks to generate jobs or looks to generate jobs that pay a salary that is higher than that region's or that municipality's average salary. So in the business plan, if a salary states that it will, let's say an entry-level job at the company is going to be $50,000 or $40,000, and the municipality that the individual wants to live in, the median salary or the average salary is $15,000, $20,000, then an argument can be made there that the client's endeavor is going to generate jobs in this region that are higher than that region's average salary. So this is a plus, right? So look at how you can incorporate the business plan into that waiver argument. So that's,
and then with that connecting the dots, right? With the business plan, the jobs, and linking it to that to that benefit.
The federal initiatives, the linking it to the academic transfer, to the courses taken, to the jobs the individual has held over the years. You got to really connect the dots there.
Okay. A lot of creativity happening there.
A lot of creative writing.
Greg, and going back to what you were mentioning about the business plan. So we have different opinions on this question. So I want to take the opportunity to ask for your 2 cents on this one. Do you file the business plan at the start or when receiving an RFE, and why?
I like to hit them with the kitchen sink if possible. Again, if we already know that starting a business is what this person intends to do, then we incorporate that at the beginning. I like to incorporate it at the beginning, right? I would like to hedge my bets and position my client for as much success or as high a chance of success as possible, right? Again, that's my role. I know that depending on when we're talking about catch it on the RFE, if the client doesn't want to present that business plan, then so be it. If they want to develop their idea, if they are, let's say they don't have the resources for that business plan at the moment, then it is what it is. But I know that there are other attorneys that will do their best to present the plan without the 5-year projections, right? They'll do everything but the market analysis and the salary analysis and all that, everything that the business plan comes with. And they'll do it post-filing at the RFE stage. And every cook has their recipe, how they like to serve it up to immigration. So really it depends upon the state of the evidence at the beginning and whether or not your client can proceed. I encourage my clients to present the business plan at the beginning. And I know that there are many other attorneys that present it just at the RFE stage and still receive an approval. So not presenting a business plan at the beginning is not the kiss of death. And presenting it at the RFE stage is still a viable way to go about it. But it's really what the comfort level of both you as the attorney and the client, as far as whether or not they want to present that evidence at the beginning.
And in your opinion, like catching it on the RFE, like the expression says, do you consider that smart or risky?
I think it's risky. Just leaving it to fate sometimes is not always the best. Sometimes you're forced to. Again, that's a case-by-case analysis there, but I'd like to present as much in favor as I can at the beginning. So again, if there are practitioners out there that will fly by the seat of their pants, that's how they practice law, and they'll present whatever they have and catch it at the RFE. And see if that's what even the officer is looking at. So in my experience, I like to, it's like walking on eggshells sometimes with immigration. I don't want to invite their wrath. I don't want to invite, the odds are already stacked against us sometimes with the RFE. Going back to that first question, how do you breach the subject with a client? It can be a 50-50 chance. Let's not make it 80-20.
Yeah.
Right. So,
exactly.
So let's try and submit as much as we can at the beginning.
Okay.
But again, submitting it at the RFE stage. RFEs, it's a difficult thing to discuss. It's just the nature of what we do. And it's not, again, it's not, if you have an RFE right now and you're listening in to see what you can do, don't give up hope. If you haven't had a business plan, and a business plan is something that can be presented, get it done, right? Or I'll even say this, if you file a case without a business plan, right? And a business plan is something that could have been presented, have a conversation with your client to start saving their pennies, put their pennies together, and save for that business plan, because the RFE may be coming. Okay.
Yeah, that's great advice. And I mean, RFEs are very common these days. What are and the RFE is the topic of the webinar, of course. So I wanted to ask you, can you tell us about one or two crazy RFEs that you've been receiving lately. What have they been asking for?
I've had RFEs that misstate the endeavor entirely. Someone in dentistry, being their endeavor, what was detailed and discussed as fashion design. I've had somebody in athletics be they received an RFE as a physician. It's like, what's going on over here? So, and to touch on something before with the RFE, the rumors circling about why that is. Why does an RFE state that nothing was received? That goes into the crazy RFEs, right? Either they'll mischaracterize, mislabel, or they'll say that nothing was received. I've seen, or I've heard with other attorneys who are, as members of AILA, have gone to site visits, like at the Texas Service Center and other processing centers, and they'll say they've come back reporting that, imagine like an Amazon warehouse, thousands of cases being received. The thing is jammed into a scanner and sorted with thousands of other cases. To use an example, they showed this attorney how a highlight, right, when you highlight something, how it comes up on immigration's scan. It looks like a redaction. So let's say you've, in good faith, you highlighted something to kind of highlight it for the officer, and now it all looks redacted. And now that you get an RFE saying, we never received it, we don't know what, there's an issue or whatever. It could be an issue at scanning, an issue with the highlight. A page could have been missing. So
the sorting,
it could be all out of order. So going to the ridiculous RFEs, something that we've touched on, the ridiculous part is saying that no evidence was submitted. So here I am thinking, is it the officer or is it the scan? The other ridiculous thing is completely miscategorizing or mischaracterizing the endeavor, the candidate, improper pronouns. You're referring to as a woman when it's a man, and vice versa.
Wow. Okay.
Like, did you actually look at the case, officer? And then the other ridiculous thing is a NOID, and an RFE labeled as a NOID. So now they've issued what could have been an RFE, but they've labeled it a NOID and limited you with that response time, because the NOID has a shorter response time. So that's the ridiculous part. So if they aren't mischaracterizing the field, they're alleging that nothing was presented, or they're jumping straight to a NOID, or a number of things, right? So, and here we are trying to explain to the client, why that is, and it's a frustrating thing. So it's other practitioners. If you're out there and you're saying, well, am I the only one? You're not.
You're not.
But those are the ridiculous things that have been occurring since I've begun practicing, or since I've been practicing this. It's always been something that's happened.
And it's good to share, like you say, like if anybody else is facing the same, it's nice that they're to know that they're not alone. Gregan, do you have any non-crazy RFE topics that have been like most common situations that you're facing and that are not so crazy?
That are common situations that are not so crazy?
On RFEs, like trends that are happening on the RFEs?
I mean, I would say really it's just jumping to the Danisar analysis, right? Or jumping to the prongs and completely bypassing the qualifiers, the discussion of advanced degree. That's something that it's not so ridiculous, but it becomes ridiculous when we get to the denial, right? So I'll use an example. It seemed innocuous at the beginning. The client receives an RFE that jumped to the discussion of the prongs, had no discussion of whether or not they found my client to be exceptional ability or possessing an advanced degree, and then received a denial that stated that they didn't find him qualifying for the advanced degree or exceptional ability, right? So I thought, since it wasn't detailed in the RFE, that, okay, it must have been approved, right? One of them. They must have either found the candidate as exceptional ability or advanced degree. I didn't realize until the denial came about that they didn't do their part, right? They didn't discuss whether or not they found them to qualify for the benefit, right? And argued that on appeal and won that appeal because USCIS should have performed that analysis, right? Whether or not they found advanced degree or exceptional ability. So something that I thought was innocuous, and sometimes I haven't brought it up at the RFE stage, right? And the case was approved. But now when I see that USCIS doesn't state, in plain language, whether or not they found my client to qualify as advanced degree or exceptional ability, I will request, right, that in my RFE response, or state that USCIS failed, right, that failed to make that qualifier, and I will assume for USCIS that they've conceded that. And that if they didn't grant that, then to issue another RFE on the matter.
So you make them work. You make them go deeper, and you make them read. That's right. Good.
So if they aren't, it seemed innocuous at the beginning. It turned out to be ridiculous at the end. It's something that I see quite commonly occur. They'll just jump to the national interest argument. And I've had, most often, it really turns out to be nothing. The officer just wanted to jump to the NIW part, but I've learned my lesson. So now I treat everything as a very risky, as something to be suspicious of.
Okay. So you were mentioning RFEs, and you were mentioning NOIDs, or notices of intent to deny. So you have told us that you received them. Do you consider that you are receiving templated NOIDs, or do you feel that the things that they are asking for are real? And also, do you handle NOIDs the same way that you handle an RFE, or do you give it a different approach?
The NOIDs that I've received are using the exact same template as an RFE. So I haven't seen any officer yet really, and the NOIDs haven't really occurred with as much frequency as the RFEs, but far less than the RFEs. But the NOIDs that I have seen are templated. The RFEs as well, most often are templates. Really, I am more surprised when I see an officer taking their time to detail all the evidence presented. And even when they do detail the evidence presented, it's usually in some way, shape, or form mischaracterized, so that their ultimate decision, the discretionary, aspect of the case to whether or not to waive the labor certificate, they kind of phrased it so that it seems like it's rational to deny the waiver. So again, I look at what they did detail, if they detailed it, but most often it's a template RFE.
Okay. And Greg, sorry, go ahead.
I was going to say, and the NOID, if it is a NOID, it's just also a template. But I do treat NOIDs with, there's urgency there. You really have to specify, really go into it far more. You should really do that with an RFE as well. But really with a NOID, it's there's a heightened level of urgency there.
Okay. So as we all know, when you get an RFE, the RFE response is going to the same officer. So if you get an RFE or a NOID where you see low chances of approval, do you recommend refiling or fighting it?
I always try to fight where I can. I've maybe that's just a personal characteristic of mine, you know, a character trait. But I like to fight. I like to. I wouldn't have taken on the case if I didn't think there was merit there, right? So we're going now. We're speaking about one's personal, you know, characteristics when you're taking on cases. If you're just trying to take on a case and you have no idea if it qualifies for an EB2 and you get an RFE and you're like, oh, let's just refile. Well, then that malpractice started at the beginning, right? So when it comes to an RFE, I wouldn't have taken on the case if I didn't think that there was merit there. If we receive an RFE, I'm sure as heck going to want to fight it. And if that RFE ends up getting a denial, then I refile it, and I will refile the petition using everything that went into the RFE. So if you're not going to respond to the RFE and you're just going to refile it, then you know that's you can act accordingly. You can do whatever you want there and add to the new petition what you could have responded with in the RFE. But I always fight my RFEs, and if the case gets denied, I will use everything that was presented in the RFE, and I will add it to the petition and refile.
And have you had cases, Greg, where after fighting, it has been denied, and then after filing with another officer, it has gotten approved?
Yes, that has happened.
Okay. Right.
I haven't had a case denied yet that wasn't refiled and then won on a refile. Okay. And I've also had cases that they've been denied, I've appealed, and then won on appeal. So, you know, there was another RFE sent and all that, but then ultimately won. But fight, that's what we're here for. That's what the client is hiring you for. And don't give up, refile.
Great. So Greg, now with premium processing as an option for the EB2 NIW, we've seen RFEs arriving in 8 days. Do you think that there are more RFEs? And can you tell us about the current backlog for the previous cases that were filed? What are your thoughts on that?
More, I can't say that there are more. I feel like it's been the same with immigration. There's always that consistent level of RFEs. But with the premium processing, I think that it goes kind of the same statistic, that 50-50 shot. When it comes to premium processing, if I recommend it, I recommend it. I know that there's attorneys out there that say, oh, you know, premium processing won't have an effect on the ultimate outcome. I like to just let it low and slow unless there's some other pressing matter that you know, that maybe a child is going to age out or some other status issue that you need premium processing. But I apprised my client of the risk, and if they want to premium process, I let them know that, look, it's an RFE. There's a risk there. Get ready for it, and go from there.
Okay. Wonderful. Thank you, Greg, for such insightful answers and out of a lot of experience. So we have a lot of questions on the chat, and it's 1 p.m. Eastern time. So we're going to do 10 or 15 minutes more, if that's okay. And then at the end, I'll mention the code. So I want to focus on the Q&A, and then we'll submit the code. For everybody who's watching, everybody who has registered, and also people who have attended, everybody's going to receive the recording at the end. So just to let everybody know. So I'm going to first mention 3 questions that I have from the registration form, and then I'll dig into the questions that we have on the tab. So from your experience, Greg, what is the most effective way to prove the third prong in an RFE?
Before I discuss that, Marianella, I wanted to just finish the last part of something I didn't touch on, the backlogs.
Okay.
I've had cases filed recently that are receiving approvals faster than cases that I had filed towards like the tail end of the pandemic. So just backlog wise, it's just everywhere. I've had cases that had been pending for 2 years, and then I had some cases filed recently that were approved in, let's say, less than a month, less than 2 months, less than 3 months, and then other cases that still are taking forever. So backlog, I think there's still backlog, and I think now that the EB1s might be even experiencing longer processing times now than the EB2s. I think EB2s are really trying to get through them. But now we're facing that visa bulletin backlog. Yes. So if it isn't one thing, if it isn't the visa bulletin, it's the delay in processing. But that's just wanted to answer that. Okay. I think things are getting back to, I think they're getting normalized. I think they're getting a bit better on answering them. But again, you never know. But to the third prong of DANASAR, it really depends on what that endeavor is and what that individual's profile is. If this individual is, let's talk about pilots as an example, right?
Great example, yes.
So if we talk about pilots, there's a lot of attorneys out there that say pilots don't qualify. There's no NIW argument can be made there. Well, again, like how we started this conversation, I don't like to use absolutes. So depending on the individual's profile, I've had a pilot approved that they were exceptional, right? And that argument was made, and I proved at least 3 out of the criteria for exceptional ability. This individual didn't have that advanced degree, and the endeavor that he was coming to bring to the U.S. was found to have national importance, and he was a member of prestigious organizations, thousands of hours of flight time, plenty of experience in educating other pilots. So if it's somebody that just has the minimum qualifications, you're really setting yourself up for failure there. If someone is going to qualify for the NIW and you're looking at the third prong, you really have to see what benefit that individual brings. If that individual is truly unique or qualified more than the minimally qualified individual. Again, remember that the labor certificate process is there for the minimally qualified individual, right? You're comparing, this is something that I've seen at the RFE stage. They will state that the individual is just merely doing their job, right? That whatever they achieved, they did so in the course of just acting out their profession. And you have to say, no, that's not exactly correct to interpret it that way. This individual is not just a pilot. This individual did all these other things as a pilot, did all these other things in their profession, right? Or to say that no pilot qualifies, then you can say that that no architect qualifies, that no engineer qualifies, right? No, it's all these professions qualify if they can prove, the advanced degree or exceptional ability, and that their endeavor is important, has merit, and that they're dispensing that labor certificate, right, will allow this person to bring a benefit, right? And you have to define what that benefit is. Is it that person's expertise? Is it there's something of cultural value? Is there something of artistic value? Is there a lack of that expertise in a particular region or in the field, right? So I had a another case where it was a very specific area of insurance that they're working in, and that specific area of insurance isn't commonly found in the US, right? So is that expertise, excuse me, is that expertise something that will benefit the US? Is it commonly found? And is it commonly held by the minimally qualified individual in the US that the labor certificate process is meant to serve? So when discussing the third prong, there's so many ways to go about it. It really is fact specific and candidate specific, but really look at what the the minimum is when in terms of that profession, in terms of that endeavor, and then look to see if your client or that the candidate that you're contemplating filing an EB2 for, if an argument can be made there to state that they are either at the top of their field, above average, or if there's some benefit there to what exactly it is that they're intending to do or intending to bring to the US.
Greg, and there's a question about pilots. Somebody asked, they don't usually open businesses. We have presented personal plans without salary projections. So are we presenting it incomplete?
That's very specific. I cannot tell you. I don't know the individual's qualifications. I don't know the specifics of that case and what else they have as far as the endeavor, what was presented in the endeavor. So in the personal plan. So I can't tell you if it's complete or incomplete. But if they're just saying that they want to be a pilot, then that's I don't think that that's a strong enough argument for the EB2 NIW, right? And I've had individuals that will say that, well, I just want to be a scientist, right? Well, what specific thing do you want to do in the sciences? What specific, is there a line of research that you have worked on that you want to continue working on in the US? And then we have to go beyond that and state, well, these are the individuals that this person has in mind to work with. These are the resources that they're going to draw in. These are the benefits of the research that this person intends to perform in the US. So it's not just enough to say, I want to be a pilot or I just want to be a scientist. You have to go above and beyond that and show that not only does that individual want to be a pilot, but they want to do something specific within aviation. And that specific thing that they want to do is going to address something of national importance or something of regional importance that can be understood to have national impact. So it's, again, that specific question, a little too specific for me to answer. But I hope that whoever asked that question, I hope I've answered your question in saying that if this person is just saying, I want to be a pilot, you're going to need more than that. And again, I would recommend that the client come to you with that endeavor and you help them kind of, we act like, to use the bowling reference, we act like those bumper bars in bowling, right? A client will kind of want to go whichever way to hit as many pins as they can, but we got to be the bumper here, right?
Exactly. Set limits
and help them, right? So try to be like that for your client.
Okay. Greg, we have a question. I'd appreciate it if you could explain about the substantial merit.
Right. So substantial merit and national importance. When you're discussing those two things, number one thing I do, I go to Kurzban, AILA link. If you're not an AILA member, there's case law that there's cases that were approved post Danisar, and see if your client fits or if an argument can be made with any of those cases. So that's something that we can go all day on the specific cases that were approved and denied post Danisar. But check your legal resources. If you're an attorney, I recommend joining AILA, using Kurzban. You can find that on AILA link, and see if you can find case law that is post Danisar that can is similar to your client's profile. Argue that, find an argument in there, and then as far as merit and importance, again, you're going back to looking at congressional websites, executive orders, federal initiatives, state initiatives, seeing what is really the need right now, what's going on, past and present, and see if your client is meeting one of those needs or is going to address one of those issues.
Okay. We have another question. When a client plans to establish a company as his proposed endeavor, USCIS sometimes makes the illogical analogy of teacher working at a school, and the benefit is only for the company and clients, nothing bigger. How have you dealt with this issue and proved national importance?
Well, you have to see there's so many trickle down effects, right? There's both indirect and direct employment that is generated by a job. And then there's so many things that clients can then, let's say if a client is allowed to generate a project, let's use a construction project, right? An engineer comes in with their consulting expertise, they're going to affect a client. That client, by virtue of my client's expertise, is allowed to proceed with a particular development or a particular project. That project will generate benefits, right? Either through jobs or a sense of place. I had an argument where an architect of mine was working with developers, right? Providing workplace safety expertise. And that allowed their clients to reduce injury, which was something that they were experiencing, right? That saves money. That saves a burden on our healthcare system when you have individuals needlessly going into the healthcare system for workplace injuries. So that's one benefit there. And they were also able to reduce time on constructing their projects, which allowed them to address more clients and more projects. So that's one example, right? So look at what exactly that client is offering, what that service is. Look to see how their clients are benefiting, and have a discussion with your client to discuss with their potential client or their current client about all the ways in which their service allows them to provide a service to someone else, right? So if I'm clear on that, use past examples as well. If you know that in the past, or there's a number of clients to draw from, ask your client to talk to their network of clients to see if any of them were, due to your client's services, were able to grow their business, if they were able to better attend or generate jobs, if they were able to reduce project times, which allowed them to, expand their business. Those are kind of the arguments that you can be made. So it's something that it's case specific, but I hope that example helps. But you really got to do the work for your client and help them exercise, the benefits of their work. Because sometimes a client will just perform their service and never really think about what that service means to somebody else. So really try to go into it and see where the benefit is there.
We have another question. What about someone in an existing job that they will continue? They are not starting their own or a new endeavor. USCIS seems fixated on startups and no longer understands when someone is employed by a company and is continuing important work through that company.
So, then now we're not really even talking about business plans, I guess, there. Now we're just talking about case specifics.
Cases, yeah, that's fine.
Well, right. So I don't know the facts of this case, but if this is, again, if this person has an employer and you're filing an EB2 with that employment sponsor, and to bring that business plan into effect, look to see if that individual service will allow the employer to expand, have that conversation, and see if, that if what that person does will allow that sponsor to expand their business. And if that's going to allow them to expand their business and hire more individuals, then put that into the business plan. But if a business plan is not what you were contemplating and it's just this individual, well, then that's too specific, and that would really depend upon the need of the individual services, what exactly they're intending to do. So I'm limited in my ability to answer, but I hope I've answered there.
And at the end, Greg, we can share how you help other lawyers, and we have also shared your website on the tab for the chat. So if anybody wants to reach out to Greg directly about a specific case or to co-counsel or anything like that, Greg is open to that. So you can reach out on his website. He has an option of receiving comments, and it says that it's coming from another lawyer so that he can reach out as well.
Right. So
yeah.
As you said, Marianella, if you go to my website, there's a portal where an area where you can submit your contact information, and there's a drop down where you can select law as your area of occupation, and that you found us through Joorney, and I'll know that you came through this talk. And I'm happy to discuss with other attorneys, and I treat it just like a consultation, a paid consultation, and I'm happy to address your questions. And if there's anything that I can assist with, I'll let you know and we can discuss. So,
excellent. Greg, I'm going to make a slight pause. I'm going to be mindful of time for those who are waiting for the code. I'm going to give the code, and then we can do a few more questions before we log off.
Great.
If that's okay with you. So let me share the code. The code is 2304331N. Code 2304331N. This is a code for a 1 CLE credit from the Florida Bar Association, and for other states who need supporting documents for them to submit for their own CLE credits, we can also provide that, so you can reach us by email. Okay, so one second. Okay, perfect. So we still have 102 people that are online, so I'm going to have a few questions, and then we can log off. So we have another question. We have gotten RFEs where the client is opening a new company. It seems that USCIS wants the company to be operating and showing investments, donations, job creations, etc. There are times that the business is so new, they do not have this type of evidence. Do you have any issues with such applicants?
I've had that as well. And remember, there's to assume that the endeavor should already be running is to impose a novel and unilateral interpretation of the law. Nowhere in the regs does it say that the operation should be already ongoing, right? Mm-hmm. So I stated in my cover letter that, and this is also stated in the business plan, that the endeavor is measured from the moment that the individual receives their permanent residence, right? This is a proposed endeavor. The benefit is prospective, right? So if you want to use the verbiage of the law, right, and throw it right back at the officer, again, I don't know what specifically they're alleging, but I have a good understanding or a feeling that it's something that I've already seen before, like with investment. They'll say, oh, well, where's the investment? Okay, that's not something that's required. There's a non-exhaustive list of things that they will consider, but that are not required. So to state that investment is required, again, is a unilateral, like, requirement, a novel imposition, right, or novel and unilateral interpretation of the law. But I will say this when it comes to a business plan. If you state, and I was just discussing this yesterday with a colleague, they received, I believe it was a denial, that they, in the business plan, it stated that substantial investments were going to be required. This was not a business plan from Joorney. I will highlight that.
Thank you for that.
This was not a Joorney business plan, but the business plan was stating that it was substantial investment was required. Well, the RFE requested the proof of investment, right?
Wow. Okay.
So if you're you're essentially shooting yourself in the foot there. If you're saying that a lot of investment's going to be required, then you should show that investment. But if I've never had that issue come up in my business plans, and Joorney, you has always discussed, what goes into the business plan. We have an opportunity to review the business plan with the client, make sure that everything is nothing's going to be prejudicial in there. So again, USCIS, sometimes they'll completely ignore the business plan, but if they look at the business plan, make sure that there's nothing in there that's going to prejudice you later on, right? So is investment even an issue? Maybe that shouldn't be discussed. And if it is an investment heavy endeavor, you're coming here to build a laboratory, you're coming here to build something, well, then maybe investment should be discussed, and there's a way to highlight, interest from potential clients or interest from potential investors. But again, if you come up with this obstacle, or they throw this at you, where is the proof? Remember that these are things that can be shown, they're not required, and it's a prospective benefit, it's a proposed endeavor, and the law does not require the endeavor to be ongoing. But let's say you're using an E2, right? You're an E2 to an EB2. If you're using that E2 endeavor and then going into an EB2, well, I would hope that the E2 has had such success that you could translate that into the EB2, and you should be able to show clients and sales and all of that. So really, it's evidence specific, it's case specific. But remember, stick to the law and the evidence, and stick to your guns.
So if it is for the NIW, investment should be mentioned only if it's part of the immigration strategy itself initially, right? And if it hasn't been mentioned, then law, go to the law. Okay. Greg, so we see that you are extremely thorough with all your cases, of course, and you have amazing knowledge of everything. We actually have a question from somebody who wants to know, how many hours do your NIW cases take?
Oh, countless. I can't give you approximate. I can't say. It's really case specific. It really is case specific. There's individuals that they have a lot of evidence and they don't know what to show, and it takes me a lot more time to go through their evidence or to develop their letters, let's say. So I really can't give you a specific answer, but countless over the years.
But it's a lot. It's definitely a lot. We have a question that is asking about the pilot example that you mentioned. They want to know what the pilot's endeavor was in that specific case that you were mentioning as an example.
Right. They had a very specific knowledge when it came to training and a particular type of training, and they were going to expand upon that, and already had individuals that were going to contract their services, a number of schools that were going to contract their services here, and that was part of the endeavor.
Okay. Okay, great. So we have some questions that are going to be case specific. So Greg, if you can repeat the fact, I mean, how you work with other lawyers for them to reach out to you, that would be great. And then we try to answer as many questions as possible. And those that we didn't get to because they're case specific, please reach out to Greg on their website that we shared on the chat. So maybe take a few minutes, Greg, to explain how you work with other lawyers.
Right. Happy to answer questions. I treat it as a normal consultation. You're welcome to reach out via website. My website, gebglobal.org. There's a contact information section. If you select your profession as law, happy to discuss the EB2 with other attorneys. There's a drop-down menu that it says how you found us. There's Joorney listed there. You select that, and happy to discuss again with attorneys what their questions are, and if they're looking to co-counsel, you can submit that information for my consideration, and then we can have a consultation on the matter and see exactly what your needs are and if I can assist you.
Okay, wonderful, Greg. Oh, I want to thank you, Greg. It has been amazing. I mean, you have so much wisdom. Clearly, you have done many of these applications. And of course, you faced RFEs, NOIDs. And thank you for sharing all that wisdom and knowledge that I'm sure a lot of people are going to find valuable for their own practice. So thank you very much, Greg, for your time. If you have any closing remarks, we still have, let me see, we still have around 88 people listening.
No, I just hope I was of some help to someone out there. And I remember when I first started doing this, it can seem daunting, but I hope I was of some help. And again, just remember to look at the law, look at the evidence, and see if you can make a connection there. And I really wish everyone the best with their EB2s.
Thank you, Greg. And you're receiving a lot of comments on the chat. Thank you, Gregory. Those are the arguments I have been making as well. Glad to see that we are not the only ones. Thank you, Marianella and Gregory. This was a great webinar and extremely informative. A lot of people saying thank you. Some people hope to see you at the conference. So thank you, everybody, for being here, for attending, and see you soon on the next one. And also see you at the AILA annual conference.
Great.
Thank you, Greg.
Thank
Bye.
you. Bye-bye.
Talk to you soon. Bye.
Talk soon.